Good afternoon. Are you Mr. Rupp?
Yes, I am.
Right. Mr. Rupp, I have a complaint that's been filed, and I'm showing that you were served a copy of that complaint along with the warrant. Have you looked through the papers?
I looked through them a little bit.
Okay. So I am showing that there are 6 counts to this complaint. What I'm going to do is I'm going to read you the charges here. I'm going to go through the sentencing grid with you. We are going to go through your rights. I'm going to make certain that you've been processed, and then we're going to talk about court-appointed counsel. All right, so count 1 states that on or about November 22nd, 2020, the above-named defendant within Norton County in the state of Kansas did contrary to the statutes of the state of Kansas, feloniously and intentionally possess any opiate, opium, or narcotic drug, or any stimulant designated in subsections D1, D3, or F1 of KSA 654107. This is charged as unlawful possession of a controlled substance, methamphetamine, which is in violation of KSA 215706 subsection A, which is a level 5 drug felony. Count 2 states that on or about November 22nd, the above-named defendant within Norton County in the state of Kansas did contrary to the statutes of the state of Kansas, intentionally obtain control over stolen property, a firearm, worth less than $25,000, knowing the property had been stolen by another. This is charged as possession of stolen property of a firearm, and it's in violation of KSA 215801, subsection A4B7, and it's a level 9 non-person felony. Count 3 states that on or about November 22nd, 2020, the above-named defendant within Norton County in the state of Kansas did contrary to the statutes of the state of Kansas, intentionally obtain control over stolen property of a firearm, which is worth less than $25,000, knowing that the property had been stolen by another. This is charged as possession of stolen property, a firearm. It's in violation of KSA 215801, subsection A4B7, and it too is a level 9 non-person felony. Count 4 states that on or about November 22nd, 2020, the above-named defendant within Norton County in the state of Kansas did contrary to the statutes of the state of Kansas, intentionally obtain control over stolen property, a firearm, worth less than $25,000, knowing that the property had been stolen by another. It's charged as possession of a stolen property of a firearm. It's in violation of 215801, subsection A4B7, and it's a level 9 non-person felony. Count 5 states that on or about November 22nd, the above-named defendant within Norton County in the state of Kansas did contrary to the statutes of the state of Kansas, intentionally obtained control over stolen property, knowing that the property had been stolen by another with an unknown value. This is charged as possession of stolen property. It's in violation of 215801, subsection A4, and it's an unclassed felony. Count 6 states that on or about November 22nd, 2020, the above-named defendant within Norton County in the state of Kansas did contrary to the statutes of the state of Kansas, use or possess with the intent to use drug paraphernalia, to wit, a black case and baggies suitable to store, contain, conceal, ingest, inject, inhale, or otherwise introduce a controlled substance into the human body. This is charged as possession of drug paraphernalia. It's in violation of 215709, subsection B2, and it's a Class B non-person felony. It's a Class B non-person misdemeanor. With that misdemeanor, if there was a conviction, the maximum fine that the court could assess is $1,000 and a maximum jail sentence of 6 months. With the other charges, there are felonies. We're going to first address count 1, which is a drug felony. So the state of Kansas utilizes a sentencing grid. I will send down a copy of this grid for you to review. I'll highlight the counts that you've been charged with. So what I'm going to do though right now is just tell you that the possession of methamphetamine is currently charged as a level 5 drug felony, which means there could be a minimum sentence of 10 months and a maximum sentence of 42 months. This, where you fall, are you familiar with the Kansas sentencing grid?
Uh-uh.
So when you get the copy of this down there, across the top of the grid is your criminal history. Down the left-hand side of the grid is the severity level of the offense. So this is a level 5. And again, I'll highlight this for you. It carries a minimum sentence of 10 months and a maximum sentence of 42 months. There's different shades on this grid of gray. The light gray area, if you fall within that light gray area, you could presume you'd be sentenced to a term of probation. If you fall within the dark gray area, it's called the border box, and the judge has the discretion as to what he would do in regards to probation or a term of imprisonment. And then the last two boxes on this grid are white. And if you fall within that within those grids, which would be A or B, you could presume that your sentence would be a term of imprisonment. Again, I'll send this down for you to review. The maximum fine that could be assessed in this matter is $100,000. So that's on the unlawful possession of a controlled substance. So counts 2, 3, and 4 are all level 9 non-person felonies, and it has a different grid. And so if you fall, on level 9, the minimum sentence would be 5 months, maximum sentence 17 months. And again, the light gray shaded area, if you fall within that area, you could presume a term of probation. If you fall within the white area, you could presume you would be sentenced to a term of imprisonment. Count 5 is an unclassed felony with a minimum sentence of 5 months and a maximum sentence of 13 months. Both of those carry a maximum fine of $100,000. So I'll send this grid down also. There's what we call the drug grid for the drug charge, and then the non-drug offense grid. And they all are a little bit different, but I'll send both of them down for you to review. We're going to go through your rights here. So you're guaranteed certain rights, and those rights are guaranteed to you by the Constitution of the United States and by the Kansas Constitution. Those rights include that you're allowed to appear in open court and defend yourself against any charges that have been made. There can be no disposition in your case without your presence before the court. You are allowed to have an attorney represent you throughout all the proceedings. In this matter, you're also, if you cannot afford an attorney, the court will appoint counsel to represent you. You do have the right to demand the nature and causes of the charges made against you. You have the right to confront, cross-examine, and question in open court under oath any witnesses that the state would have. You have the right to subpoena witnesses to come in and testify on your behalf. You yourself are not required to be a witness. However, you do need to be aware that you don't have, I guess what I really want to say is that means you don't have to answer any questions in regards to anything that's occurred, and it's not relevant as to your guilt or innocence. You do have the right to remain silent or stand mute. However, you do need to be aware that should you make any statements, whether they're made orally or in writing, that anything you say, sign, offer could be used against you in the court of law. You do have the right to be released on bond. And I'm going to just address with you anybody who is charged with a possession of methamphetamine charge in Norton County. The bond is automatically set at $100,000. That doesn't mean that it can't be changed at some point, but upon initial arrest, that's where it sets. So that's where your bond is currently. The court's going to set a preliminary hearing. I am required by statute to set that within 14 days. At that preliminary hearing, the court has to determine whether or not the felonies charged have occurred and if there's probable cause to believe you committed those felonies. If the court makes that probable cause finding, you will be bound over to the district judge who has jurisdiction to try the case. So if you are bound over, you'll be required to stand trial, and you have the right to a speedy and public trial by a jury. And if you are convicted at that trial, you do have the right to appeal the decision of the court or jury. Do you have any questions in regards to your rights?
No.
Okay. Mr. Rupp, have you been processed? Have you been fingerprinted on this warrant?
I don't think so.
Well, I'm going to have the sheriff's office process you on these current charges. I need to ask you about court-appointed counsel. Are you wanting to apply for an attorney, or are you trying to retain an attorney?
I don't need an attorney.
Okay. Are you going to be hiring somebody?
I don't think so.
Okay, so you're going to represent yourself?
Yeah.
Okay. So if that's your choice, I need to advise you of some things in regards to self-representation. So hang on just a minute. I'm going to get that document, and I'll be right back on.
After she gets done, I'm gonna take you across and get your fingerprinted. Okay? I don't know if this is your sister,
Yeah, that's my sister.
Carly.
All right. So, Mr. Rupp, I have to advise you of all of this. If at any time you have any questions, please stop me and I'll try and answer any of these questions. So I just advised you and informed you of the charges that are pending against you. And if at any time you want to change your mind and your desire to have counsel or represent you, you'll just need to let the court know that. But I will also advise you that a lot of times postponements are not granted just because you decide suddenly you want an attorney. The court will have the right to terminate any self-representation if you deliberately engage in serious misconduct before any of the court proceedings. I will tell you that it's detrimental for you to represent yourself in a court proceeding like this. You'll be required to follow all the legal rules that are applicable to a criminal charge. And I'm going to tell you with the numerous disadvantages of self-representation. So the law provides for numerous pretrial motions that are available to you, which are technical in nature and the advantages of which the defendant would lose if allowed to represent him or herself. Your vocabulary may impede clear communications with the court and the prosecutor. I cannot act on your behalf in asserting objections or making appropriate motions where ordinarily it is the duty of your attorney to call such matters to the court's attention. The county attorney cannot assist you in any way in the defense of your case. The rules of law are highly technical and will not be set aside just because you're representing yourself. You may waive some constitutional or statutory or common law rights unknowingly. And if you're in custody, it could be difficult for you to locate any witnesses or interview them or prepare subpoenas and have them served upon those witnesses. So you and I went through the maximum sentence on each of these counts. Do you have any questions about that?
Nope.
Okay. So I will prepare this document, and you will need to sign this document showing that you are waiving your right to an attorney. Again, if at any time you choose to have some attorney represent you and you're not able to afford an attorney, you can petition or request from the court an application for court-appointed counsel. All right, do you have any questions?
Nope.
All right, so I'm going to send down a copy of the waiver that you will sign and return back to me. In addition, I'll send down a copy of the sentencing grid and let you have those. Those will just be for your review. And I have set your preliminary hearing, and it's set for the 9th of December at 3 o'clock. All right,
Yes.
I'll get them sent down this afternoon.
Okay.
All right,